Hi, thank you for your post. And this post was on my video response to your previous post. And what you say here is, oh, it was a blanket decision at my agency that all approved RAs were rescinded, changed to interim, and then 57 of 61 previously approved were denied. So now I understand a little bit better what you were saying. I thought you were saying there was some type of policy that they were just denying everybody's RA and giving them nothing. What this is they're changing a approved accommodation, a permanent approved accommodation, as permanent as it can be, to an interim, right? And even if they call it an interim, it is still accommodating you as long as they're not changing the RA itself. Then you say on here, 57 of 61 that were previously approved were then denied. Still not a blanket there, right? Because apparently 4 of those were approved. So the issue then remains, which is different than what I was understanding in the previous video, is whether or not any of those 57 have a basis to challenge the decision. Now, what's happened in this administration, and I've talked about this before on this channel, is that they have basically started looking at these things strictly, where before most agencies, if they could give it to you, were giving it to you really whether you were really entitled to it or not. This administration, basically doesn't want to give any telework whatsoever, for example. So they're basically saying, hey, I want you to look at every single one of these requests. So that by itself, while it seems suspicious and you would want an attorney to look at it if you were one of the 57 for sure, or at the very least consider filing an EEO over it, that still wouldn't be a blanket denial. It would be a blanket changing an approved RA to an interim RA, but an interim RA is still an RA. It's not a violation of law if it's labeled as interim. It meets the requirements. Otherwise, as long as the RA doesn't change, as long as it is reasonable and allows you to perform the essential functions of your job. So, and certainly 4 of these, again, apparently still have their approval. The other 57 do not. And if any of those 57 need an accommodation that is certainly reasonable and possible, not an undue burden, and they're not getting it, they need to think about filing a claim and moving forward. So, hope this helps.